Welcome to today's webinar, Adjusting Your Life to Suit Your Adjustment. I'm Rita McCarthy, and my co-presenter is Khandi Sokoni. A little bit of information about us. A disclaimer, before we begin, I want to caution you that the scenarios presented in this webinar are for informational purposes only. This is not a legal advice. Sorry about that. This is not legal advice on any subject matter. Because the facts of each green card applicant's case can vary widely, there is no one-size-fits-all answer to every immigration question. You should not act on this information without seeking legal or other professional advice. Please consult an immigration lawyer with any specific questions. Introduction. During today's webinar, Khandi and I will discuss some common travel, work, and maintenance of status considerations that arise while an application for adjustment of status, also known as a green card application, is pending. The scenarios presented are some of the questions we see come through our doors. Of course, these do not cover all possible issues. To get started, we want to explain some of the terms and abbreviations we will be using today. As this webinar has to do with the do's and don'ts of adjustment of status, the key term for today is adjustment of status, also called AOS, which is the process of applying for permanent residence in the United States. There's another process for applying for permanent residence from outside the United States, known as consular processing, but we will focus only on adjustment in this presentation. Since most adjustment applicants also apply for related work and travel authorization, we also will be referring to those documents throughout this webinar, using EAD to refer to a work authorization document and AP to refer to a travel document. Without further ado, I would like to turn this over to Khandi.
Okay, hello everybody. Thank you so much for tuning in for this webinar on covering the do's and don'ts of adjustment of status. So I will cover scenario 1 involving Joe Uno. These are all totally made up names, by the way. So the scenario before us is that Joe has been an F1 student for years, pursuing a PhD in biomedical engineering. Joe secured an OPT work authorization internship with a US company after graduating. Joe and his girlfriend, who is a US citizen, want to tie the knot. How will getting married and applying for a green card affect their lives? So the thing with this scenario is keep in mind the F1 visa is a non-immigrant visa. So you always have to show that you have a foreign residence that you intend to return to. And you have to, whenever you're trying to enter the US as an F1, you have to show non-immigrant intent. So once they file an immigrant petition and an AOS application, I guess the question is, will Joe be able to use his F1 visa that's in his passport for travel to visit family in his country of birth, which is Ireland, and return to the US to pursue his OPT employment in the US? The answer to that question is no. Like I said, F1 is a non-immigrant intent status, so Joe would not be able to use the F1 visa stamp in his passport. Remember that F1 students have to show ties to a foreign country that they intend to go back to. Once you file the AOS application, you can no longer show that you have no intention to stay in the US permanently. Also note that by traveling before receiving his AP, his advanced parole, he would abandon his adjustment application. By returning on AP, Joe would lose his F1 and therefore his OPT. So it's critical that he waits for the advance parole to be approved before he makes a trip abroad. So Joe and his fiance have another question. Joe's OPT employer is eager to continue Joe's employment long-term. With a green card as an option, is there any need to pursue, say, an H-1B visa? The answer is maybe, and very likely yes, because there really are some tangible benefits of petitioning for H-1B, even when you have a green card pending. H-1B is one of the few visa categories that is a dual intent category and could offer certain travel conveniences. These will be addressed in a bit more detail later in the presentation, especially in scenario 5. They have another question. Joe applied for AOS and he and his employer finally decided to move forward with filing for change of status from F1 to an H-1B. So Joe was lucky enough to get into the lottery and there's an H-1B option. Joe's OPT EAD card expired on January 30th, 2021. You remember that F1 students, after their OPT expires or after their studies are complete, they have a 60-day grace period to leave. That 60-day grace period expired on March 31st, 2021. Is Joe eligible for a change of status from F1 to H-1B? And the answer is no. Keep in mind that F1 visa status is a visa status and H-1B status is a visa status. So if you want to do a change of status, you have to have a status that you're moving from and a status that you intend to move to. As someone who has filed an AOS application, Joe at this point is no longer in F1 status. The pending AOS application does not really help because he now has no underlying status that he can change from. A pending AOS permits the applicant to remain in the US in what is called a period of stay authorized by the Attorney General. This period of stay is not considered a visa status from which you can change. So he cannot do a change of status from F1 to H-1B.
Okay, now we have scenario 2, Jane Doe. And you may notice a theme with the names. We have Uno, Dos, and I bet you we're going to have Mr. Tres later on. Scenario 2, Jane Doe. Jane is an F1 student who will complete her studies this coming May. She's married to a US citizen and has a pending adjustment of status application. She would like to maintain her F1 status and apply for OPT work authorization. Will Jane be eligible for OPT despite her pending AOS? The answer, does Jane's pending AOS preclude her from applying for OPT? As an F1 student, Jane may apply for OPT and if she's eligible, STEM OPT while her AOS application is pending. As long as she complies with F1 regulations, her SEVIS record will not be terminated and she should be eligible for these benefits of the F1 status. You may be wondering why Jane would even be interested in maintaining her F1 status and applying for F1 student OPT work authorization if she has a pending adjustment of status application. Well, whenever possible, it's good to maintain the underlying non-immigrant status because it provides a safety net in the event there's a problem with the AOS application. And also, USCIS often processes OPT EADs more quickly than it does AOS-based EADs. So if Jane had a job that she would lose if she couldn't begin by a certain date, and then it would be likely that she would receive the AOS EAD before she would receive the OPT EAD before she received the AOS EAD, that would be a reason for her to really want that OPT EAD.
Scenario 3, Tim Tres. So this is a long one. Tim is a citizen of Bangladesh with E2 investor status, which expires on June 30th of 2021. Tim's E2 employer is interested in sponsoring him for an employment-based green card as an outstanding researcher. According to the US Department of State's visa bulletin, immigrant visas are currently available for citizens of Bangladesh in his employment-based category. However, even if the I-140 petition is filed by premium processing, the processing times for an AOS application is estimated at about 20 months, and the processing time for an advanced parole AP application is approximately 7 months. Tim's employer needs him to travel on international business between June and August. Tim and his employer are weighing whether to hold off on filing the I-140, 485, until after the June-August travel commitments, or to go ahead and file the green card. Question: should Tim and his employer wait to file the AOS until after his travel, or should they get started as soon as possible and get that AOS filed so they can get the clock ticking because of how long these applications are taking these days? Now, this scenario brings to the fore some competing considerations for the foreign national, for the employer. You have, we mentioned earlier in some of the earlier scenarios, once you file an AOS, if you travel before you get your AP, you could be deemed to have abandoned that application. There are some exceptions, but in general, you would have abandoned that application. So they're balancing these competing interests. And then, of course, given the time frame we gave here, is he going to have a travel document he can use for that travel? So the answer here about whether they should wait or whether they should go ahead and file, once Tim files for AOS, any travel before securing an AP travel document would result in abandonment of the AOS application. That's certainly a really important consideration for them. It makes sense for Tim to hold off on filing the AOS until after the required travel. Remember, it's taking about 7 months before you get an AP travel document. So if he wants to travel around between June and August, it's probably best for him to wait, travel first on his existing E2 visa. Once Tim returns from travel, they can then file a concurrent immigrant visa petition, as well as an adjustment of status application, which will then require Tim to remain in the US until the AP travel document, which takes about 7 months, until that is approved and received.
So scenario 4, Jenny Quatro. Jenny is a Canadian citizen, and she's working for a US company in TN status. She's married to a US citizen and has a marriage-based AOS pending. Jenny's approved TN work authorization expires in 6 months. May Jenny's employer extend her TN status? May the US company Jenny works for file for an extension of her TN status? And the answer is no. The TN classification is one of the few unambiguously non-immigrant visa categories. And there is some guidance on this that says that once you file for an AOS, that you as the TN worker are no longer eligible for an extension. So that means that Jenny would have to depend on her AOS-based EAD, or for a change of status. And this illustrates that there are times when it is impossible to maintain the underlying non-immigrant status, even if you and your employer would be willing to do so. This is another reason why you would want to work with an attorney who can help you work out timing issues, just like Khandi talked about in the scenario 3, where timing was so important. This is a similar type of situation. And working out those timing issues ahead of time would mean that both you and your employer are prepared for what's coming in the future. So, for example, you want to find out, when will your current TN end? And is there another non-immigrant status that you can change to, such as the H-1B classification before your TN ends? Now, we know that new H-1B visas are only available at certain times of the year, so that might not be an issue, an option there. But maybe Jenny works for a exempt employer, so that she would be eligible for an H-1B at any time of the year. If she's not eligible, if no other non-immigrant classification is possible, will she have her AOS-based EAD before her TN runs out, so that she can move seamlessly from the TN EAD to the AOS EAD without a gap in work authorization? And if none of that is possible, is there an unavoidable gap between the end of the TN and the approval of her AOS-based EAD that will force her to stop working to avoid unauthorized employment? And is there a way to minimize that gap? So their timing is really essential when you are looking forward and would like to maintain work authorization throughout this process.
Scenario 5 with Cinco. Cow is an H-1B worker at a US tech company whose status expires in November of 2021. Cow filed an AOS application together with a related EAD and AP applications. Cow is married to a US citizen. May Cow's H-1B status be extended, and can he travel? So question 1, may Cow's H-1B status be extended while his AOS is pending? Now, so far, Rita and I have covered the unambiguously non-immigrant categories, such as F1 and the one Rita just covered, which was the TN. With TN and F1, there's just no way around it. Those are non-immigrant statuses, and they do not allow for dual intent. The beauty with the H-1B is this is one where the regulations very specifically provide for the fact that H-1B status is a dual intent status. Therefore, you can hold H-1B status while having a pending AOS. And when you're entering, you don't have to show, when you're in H-1B, you don't have to show a foreign residence that you have to return to. And you don't have to show that you have no intention of staying in the US permanently. So to answer the question, can his H-1B status be extended? Absolutely, yes. Cow's H-1B status may be extended as long as the H-1B is maintaining H-1B status by continuing to work according to the approved H-1B petition. There is some authority suggesting that extension is also possible for certain other non-dual intent categories, such as E1 treaty and E2 treaty investors. There's an INS memo specifically stating that an E1 or E2 may maintain status or obtain an extension while at the same time pursuing AOS. The memo states that an application for an extension of stay that is timely filed on behalf of an E1, E2, H1B, or L1 may be approved in spite of the alien's pending application for adjustment of status. But that's, by the way, I'm quoting that language straight out of this INS memo. So it still uses the term alien. I know there have been recent developments to stay away from that term and use terms like foreign national, but that's a quote right out of the memo. So in this case, yes, Cow can extend his H-1B status because H-1B is a dual intent. Scenario 2, Cow's brother is getting married overseas. Cow does not have an advance parole document, but he does have a valid H-1B stamp in his passport. Will Cow be able to travel to attend the wedding without receiving his advance parole travel document first? And remember earlier in scenario 1, I said we'd cover a bit more detail about the H-1B. So this is it. Yes, an H-1B worker who is an applicant for an adjustment of status application and who wishes to travel outside the US and then re-enter while the AOS is pending may travel using the H-1B visa without harming the adjustment application. So in this case, the adjustment application would not be deemed abandoned. Unlike the F1 or the other categories we had mentioned, an H-1B who travels while the AOS is pending will not abandon, it will not harm the AOS.
One of the things that we're talking basic immigration here, but Khandi, we're not really discussing some of the other impediments to travel that are due to the pandemic. So while an H-1B can travel without harming their pending AOS, travel may be something that they really should think about twice, because if they need a visa, they may not be able to get a visa appointment, or there may be a travel restriction that applies specifically to the country to which they're traveling. So
that's a really good point, because we're focusing here on immigration. There may be other CDC considerations and other issues in other countries that you need to be concerned about.
Right.
That could affect your return. Yeah, thanks, Rita. Second question, the third question, will international travel impact Cow's pending advance parole application? So we cleared the fact that it will not affect his AOS application, but what about the advance parole travel document application that's still pending? Yes, the first time that an advance parole applicant, now just to back up a little bit, we've been throwing these terms out, but the assumption here is that you're aware that when you file for adjustment of status, that's an application that usually goes with, it's accompanied with the advance parole application, the EAD travel document employment application. So once you file that adjustment application, and let's say the AP application is still pending, the first time an H-1B makes such an application, they must remain in the US until the application is approved. It doesn't matter whether you're an H or L holder that allows dual intent and all that. Once you travel abroad, while your advance parole application is pending, it will be deemed abandoned. There's a little more flexibility in cases of people who have previously held an advance parole and are simply renewing it. USCIS takes the position that an individual who has a valid AP document and has a pending renewal application will not abandon the pending AP application as long as the currently valid AP document is valid for the entire duration of their time abroad. That means it must be valid when you leave and it must be valid when you return.
We find this is a common issue raised by many of our clients who have pending adjustment applications. Pending advanced parole applications. There's a marriage, a wedding overseas they want to go to, or there's a family emergency they want to attend to, and This is something that is really important to raise with your attorney if you do have a pending adjustment of status application along with a pending advanced parole application, because you will want to determine if your advanced parole will be deemed abandoned. Are you willing to lose whatever time you have already put in waiting for it to be approved? And then do you have the proper documentation in order to return? If you, so you would have to be an H or an L in order to travel without advanced parole. Do you have the visa that's needed for you to return? So these are really important considerations. They are raised regularly with us, and it's really important for you to work that out and come to some sort of agreement with yourself as to what you're willing to give up if you have to travel and give up that advanced parole application.
I should also mention that if there are certain extenuating circumstances under which you can actually request to have that advanced parole application expedited, if there was a family, if there was a real emergency, that's a subject of a whole different presentation. The importance of consulting when you have that kind of situation before leaving and possibly risking abandoning the AP application is that you may in fact be able to expedite it if you qualify. There's a whole set of criteria that might help you qualify for an expedited processing of that application, rather than risk abandoning it.
Okay, scenario 6, Susie Seis. So Susie has an H-1B approval notice valid through June 2022. She has an AOS pending and recently returned from travel outside the US to resume her H-1B job. Susie did not have a valid H-1B visa in her passport, but she did have a valid AP document. So she returned using that advanced parole travel document. Will Susie be able to go back to her H-1B work? Can Susie be put back into H-1B status after using her AP document to return? And the answer is yes. According to Kurtzban's, an authoritative immigration reference, there is a memo from Cronin. The Cronin memo of May 2000 says, yes, Susie can be put into H-1B status. Although her H-1B status is no longer valid upon her return, she may continue to work for her H-1B employer in the same position she was in prior to international travel. To regain her H-1B status, her employer would file an H-1B petition for her. And if the petition is approved, her parolee status will terminate and she returns to H-1B status. This is the same situation for an L1 worker who enters on advanced parole. This is a bit of a hard concept because it seems so counterintuitive. We're so used to USCIS narrowing benefits that this broad benefit seems unusual and a little out of place. But USCIS indicated that it intends to publish a final rule covering this subject. However, until the final rule is published, it's the position of USCIS that if you're an H-1B worker who leaves the US and returns on advanced parole, and you resume your H-1B job with your H-1B employer, you can be put back into H-1B status. So the key is that you come back and you work as an H-1B as if you never left. So in this case, Susie had the H-1B approval that was still valid. She returned on her advanced parole and immediately resumed working according to her approved H-1B petition. And since she's done nothing to violate her H-1B status, she can be put back into it if her employer files an H-1B petition. This would not be the case if Susie returned and didn't resume her H-1B employment. Okay, now, because she entered as a parolee, does Susie now need separate employment authorization to work? And the answer is no. Susie does not need separate work authorization. And this is part of that same memo that, provided information on these points. And if she was admitted as a parolee and continues to work in accordance with her approved H-1B petition, she does not need separate work authorization. This doesn't come up often because most AOS applicants who have advanced parole also have AOS-based work authorization because they usually are applied for together and issued as one combined document. But if it does come up, you can look to this memo as I stated, and that memo says that an AOS applicant's otherwise valid and unexpired non-immigrant work authorization, the H-1B in this case, is not terminated by a temporary departure from the US if prior to that departure, the applicant obtained advanced parole. So a final rule is expected on this issue, but we haven't received one yet. And the outcome is that the employee has work authorization as if she never left.
So our next scenario 7 with Sarah Siete. Sarah applied for adjustment of status and received an AOS-based EAD card. The EAD card expires tomorrow on April 10th. Sarah filed an EAD renewal application on February 1st, 2021. That application is still pending. What is Sarah going to do about work authorization after tomorrow? Question 1, may Sarah continue working after her AOS-based EAD expires on April 10th? Now, this question really highlights, we've been seeing horrendously long waiting times on the processing of EAD cards. Now, luckily, in certain categories, USCIS will automatically extend work authorization for certain expiring EADs. Keep in mind, this does not apply to all EADs, but certain specified EAD categories. But there are certain conditions that must be met first in order to take advantage of this automatic extension. The renewal application must have been filed before the current EAD card expires. In this case, good planning on her part, Sarah did file her application in February. I think we said February 21st. She filed at some date in February, so she meets that first condition of having filed before the current EAD expired. The second condition is that the EAD renewal must be in a category that is eligible for an automatic 180-day extension. And luckily for Sarah, when you have a pending AOS application, that category is considered C9. So that is one of the enumerated categories under which you are entitled to the automatic 180-day extension. The third condition is that the category the category on the current EAD and the category requested on the renewal EAD must be the same. So this automatic extension doesn't help you if your prior EAD was in a different category. Let's say it was an OPT card, and now you're renewing based on a pending AOS. They have to have been in the same category. Then you will get an automatic 180-day extension. For example, if Sarah's current EAD lists her eligibility category as C9, which is the category for pending AOS applications, and her renewal meets all of those conditions, which we said that it does, then she will be eligible for this automatic extension, and she'll be able to work for at least 180 days beyond April 10. And I know the focus of this presentation is AOS applications and what you can and cannot do, but a related question on this scenario that we do hear from employers is, how do I handle the I-9 re-verification? There is some guidance. USCIS does provide guidance. What you do is come April 10, which is the expiry date, then you can do your re-verification as long as you have the receipt notice and you can re-verify. You push out her work authorization date 180 days. And also just note, this automatic extension that you get on the EAD card, which is 180 days, is different from the automatic extension you get that H-1Bs who timely file their extension get an automatic 240 days extension while their the petition is pending. So just for those of our clients who are HR professionals, just keep that difference in mind.
Hey, Khandi, have we found that for some of our EAD renewal applications that some of them are bumping up against that 180-day mark without the EAD being, the renewal being approved yet?
Yes, that is an issue. It's a real concern. And that's why I was saying we've had these horrendously long waiting times. But at that point, you know, when you get to that point where it's really, you're up against the wall, we can, you know, make an inquiry with USCIS, but that is happening. And just keep in mind, this automatic extension only gets you 180 days. So in the event that they went past 180 days and you don't have that card, the person would have to stop working, unfortunately.
Right. And have we ever considered whether there is a possible way to expedite it if they met the requirements?
Yes, yes, that is something that it's certainly worth pursuing. If you meet certain criteria, we can request an expedite. Keep in mind, though, that USCIS takes the position that, you know, for instance, one of the criteria you can show when requesting an expedite, requesting that an application be expedited, is that you suffer financial harm. Well, the problem there is the mere financial harm that occurs from USCIS not processing an application within the estimated time frame is not a qualifying condition of financial harm. So they're difficult to qualify for, but it's worth having someone sit down and look at whether you do qualify for an expedited application, especially if the financial harm actually relates to the employer. If you can show that this is a key employee, this is an area in which if you lose, if you had to take them off of payroll, your whole program might collapse. That's a kind of qualifying harm that might get you an expedited application.
Right. Okay, scenario 8, Ali Ocho. So Ali is interested in changing employers to accept a full-time permanent job offer with another employer. He has a pending AOS application that is based on an employment-based immigrant visa petition filed by his current employer, offering him a permanent full-time job as a software developer. The immigrant visa petition was approved, and Ali's AOS application has been pending for a year. Ali's prospective employer is offering him a full-time permanent job as principal software developer. Will Ali be able to accept this new job? May Ali change employers and accept a new full-time permanent job, even though the new job was not part of the employment-based immigrant visa petition approved by USCIS? The answer is that certain employment-based AOS applicants may change jobs or employers while their AOS applications are pending, but they must meet certain requirements. Those requirements are that they must have the approved employment-based immigrant visa petition. The AOS application must be pending 180 days or more. So if you file that AOS and 1 month later you want to change jobs, you do not qualify based on this benefit. So 180 days is a really key factor in this analysis. And the new job must be in the same or similar occupational classification as the job specified in the approved immigrant visa petition. And once you're satisfied that you meet all of those, you can file for this change by submitting a specific form. In this case, Ali meets provisions 1 and 2 because, as we said in the scenario, that he has an approved employment-based petition and his AOS application has been pending more than 180 days. He also meets provision 3 because the jobs offered to the new employer qualifies as same or similar. So this benefit is for individuals who are beneficiaries of employment-based. This is when an employer petitions for you. We often see this issue come up for individuals who are nationals of countries with a very long green card wait time. So they get so far in the process and then everything just stalls while they wait for them to move to the front of the line for their country and an immigrant visa become available to them. They may start the green card process. They often start the green card process with one employer, but then down the line they want or sometimes need, sometimes an employer is going to fold its business and they have to move to another employer somewhere down the line. This benefits the result of the American Competitiveness in the 21st Century Act, and we often refer to it as AC-21 portability. So if you are ever working with an attorney and they talk about AC-21 portability, this is probably what they're talking about. And as noted, it's very important to meet all the requirements. Determining that the AOS has been pending at least 180 days is essential, but probably the easiest part of this analysis. Whether the job qualifies as same or similar could be a harder determination. Same occupational classification means the jobs, the job for which the employer petitioned and the job for the prospective employer are the same in every respect. Similar means they share essential qualities or a marked resemblance, and an analysis is done to I think we see more often that the jobs are usually require a similarity analysis. And that's where an attorney is really an important help in this process, because we know what USCIS is looking for, and we can look at the factors such as job duties, skills and experience required, educational requirements, offered wage, how the Department of Labor classifies the occupation, and we can make that analysis. And often that analysis becomes complicated when you have a job progression. Your software engineer that was part of a perm application 10 years ago is now being offered a job as chief technology officer. Can we do a similarity analysis that would make make this a good change for the individual? Once that analysis is done, then there is that form that gets filed, and that can be filed either with USCIS while the AOS is pending, or at the time of the interview. Either way is acceptable.
So we wanted to make sure we allowed some time for questions. And while Rita was wrapping up the final question, the final scenario, I actually took a look at the chat box, and Christina, who has been amazing helping us put this all together, will help us track the questions. We did present this as the do's and don'ts when you have an AOS application pending. So we'll try and prioritize the questions that are specific to the things you can and cannot do while you have a pending AOS application. I do see that we appreciate everybody's attendance, and we appreciate the, lots of comments on the chat box, but some of the questions actually are not directly related to the topic. So if we can, we may get to a few of them, but we'll prioritize the AOS related questions. One question I see in the box, and it's kind of borderline as far as whether this is directly on point, but there's a question, Rita, I don't know if you want to chime in with regard to people with who've been waiting for, they've got immigrant visa applications pending with NBC for so long, and they're now wondering whether they should convert to an AOS and whether that's possible. This is someone who says they are in the US, so they trying to weigh whether it's a good idea to do an AOS application. Even as we answer these questions, I just want to remind everyone about the disclaimer we gave at the beginning. We're not able to give legal advice. To have your specific situation analyzed, you have to engage an attorney this is not legal advice, so we're not able to do that. But we can just talk in broad strokes and general terms about the do's and don'ts around AOS.
Right. So the question about converting from consular processing to adjustment.
I'll read some specific questions from the chat here, and I apologize to everyone. I'm not an attorney, so I'm probably not going to be the best at knowing what is and is not on topic, but I'll do my best. Khandi, do you have the ability to respond to the question from Billy? I have been in the US for over a year now. Is there any benefit for filling an N-470 application to preserve residence for naturalization purposes?
I saw that question, and the filing of an N-470 is a very specific benefit. It's not a broadly available benefit. It's only available to people who have to be abroad with an international organization. So it's folks who are with the World Bank or some UN related agency or some US corporation based abroad, and you're trying to preserve your residence for naturalization. That's actually not direct. That's not connected to this topic at all. What I would encourage you to do is, we actually did a webinar some months ago on preservation of status for purposes of naturalization, and that I think is available on our website.
It is, yes.
Yeah, I would direct the person asking the question to take a look at that, and then maybe to provide you with some general information. But there was a question about whether someone with a long-standing NVC application. So when you qualify to get a green card, there are two adjustment of status is only, as Rita explained in the introduction and when she was introducing the terms, that's the way you take your final step towards getting a green card, only if you're already present in the US. People who are outside of the US, their only option is the immigrant visa application through the consulate. So that's consular processing, as opposed to if you're in the US and you're eligible, then you can adjust. But I guess, do you have any thoughts, Rita, on whether if the consular is taking too long and you're in the US, assuming you're eligible, we're going to make lots of assumptions here. Can someone convert from an IV NVC application to an AOS application?
It's my understanding that you cannot have both, although I know that it has happened. But I think it should be possible to convert from NVC to AOS. But
yeah, that sounds right to me. That I don't believe you can have them running side by side, but you can convert. And I think that's one of those situations that you need very specific. You need someone to take a look at that and determine whether, first of all, whether you're eligible to file AOS to start with, which we didn't really cover. Here we're assuming you have an AOS filed. What are the things you can and cannot do? But as far as screening you for eligibility for the AOS filing, that's something someone can do for you. And then at that point, a decision would have to be made about whether you're keeping the AOS application or and withdrawing the NVC application.
We have another question here from Nathan. He says, my wife came here on an ESTA before we married and applied for AOS. Is she allowed to drive on an international driver's permit while we wait for the results of that application?
Driver's licensing rules are actually, that's not an immigration regulation. That's state specific. You have to check with the rules in your state about recognition of foreign driver's license. The thing though is that a lot of states tie the expiry of your driver's license to if you're in a non-immigrant visa category, New York State, for instance, if you're an H-1B and your visa expires on December 31st of 2021, there's a notation on your New York driver's license that your driver's license expires on December 31st of 2021. It's a state-specific rule. You'd have to check with the Department of Motor Vehicles in your specific state.
I have one more question from Pedro. I'm on a pending AOS based on an EB1 I-140 filed 14 months ago in Texas and waiting for the new AOS and advanced parole. Are you seeing a substantial increase in the times for both renewal and AOS? Must I stay in the EB1 category of application in my case or not?
So are we seeing a substantial increase in the processing times? Is that the question?
I assume so, yes.
And the answer is yes. Everything just generally is taking longer. There have been so many closures and reopenings that things have been slowed. So that is one thing that we are finding across the board, whether it's waiting for a receipt notice or waiting for an actual document to arrive. It's just a complete slowdown. And then, of course, there was a massive filing period that occurred in October 2020 because of something that occurred. And so that even put things, slowed the pace even further for these all these applications. What was the other part of the question?
The other part of the question was, must he stay in the EB1 category of application journalism in this case while the AOS is pending?
Well, the EB1, it could have either been filed by the employer or his own, was the EB1 So the EB1 says that you will continue in the field. So I don't know, it's not necessarily tied to employment, particular employment. And I wouldn't know if he did so he did a self-petition. Yeah. So he would, it's not tied to a particular employment or job, but it is tied to his extraordinary ability in a particular field and his continuing contributions to that field. So as long as that's occurring, you know, that's essential to this petition.
Thank you. So this isn't necessarily on topic, but since we have no other questions, I'll throw it out there to you guys. This person, Jyoti, says, I have a position description October 2013 EB2 application. Can I downgrade to the EB3 based on the April visa bulletin? Priority date, not position description. My bad. So again, the question was, I have a position description from October 2013 in the EB2 category. Can I downgrade to EB3 based on the April visa bulletin?
So that's exactly what I talked about what happened in October 2020 was that immigrant visas, the immigrant visa availability moved forward by so really leaps and bounds, which resulted in individuals being eligible to apply for adjustment of status, but they had to apply in a category that wasn't the original category that they were looking for. So yeah, we have done downgrades nowadays. We don't even call them downgrades anymore. We call them additional I-140 petitions in the EB3 category, and an EB2, an individual with a I-140 petition that is approved in the higher EB2 preference category can always go down to the lower EB3 category, but it's not vice versa. So they cannot move up. If they were in the EB3 category, can't move up to EB2.
All right, great. Since we have 2 more minutes, I have one final question from Pedro, who asked us about the EB1, who has the EB1 and is waiting for an AOS. He says, should I wait for an RFE to submit my medical exam, or can I do it now? Or do I wait for the interview and take my medical exam with me?
Most of our clients who do not submit their medical exams with their adjustment applications, they receive a notification from the Immigration Service saying that the Immigration Service is taking note that a medical exam was not submitted and that will need to be submitted at some point. And then many of ours who are going to be processed without an interview then just receive an RFE asking for the medical exam, which is then submitted, and then the green card application is usually pretty quickly thereafter processed and approved. It's our position that just submitting the medical exam without any specific request by USCIS is not a good idea, because getting that mail to be linked to an application can be a challenge, and things can often be lost, and medical exams can be pretty costly. So you wouldn't want to submit that and then have it never get linked and noted, yeah, as part of your application. So our clients wait.
And just to add to that, you know, medical exams are only valid for a certain period of time. So that's why we typically don't submit them at the outset, because these things are taking so long to process. And as Rita mentioned, the medical exam is so expensive that, you know, you want to fight it closer to when you want to fight it in connection with the interview, so you know it will be current. Because years ago, when it routinely medical exams were submitted along with the underlying application, it is listed as one of the required evidence, pieces of evidence. But then with applications taking upward of 20 months to get processed, your medical exam becomes stale, and then you have to do another one.
All right, well, thank you, everybody. That brings us to our time for this presentation. So I will be posting a recording and the slides of this webinar on our website later today, and I'll also send that around to anyone who registered. And with that, thank you, everyone, for your attendance today.
Thank you very much. Bye-bye.
Thank you.
Thank you.